Good morning or good afternoon, everybody. We'll give everyone just a few seconds to filter in and then we'll get started. Thank you all so much for joining us, our very first webinar of 2024. Alrighty, hello everybody, and welcome to the Environmental Law Institute's very first webinar in the new year, Federal Administrative and Legislative Updates, wrapping up 2023 and looking ahead to 2024. My name is Sarah Viken. I'm the Manager of Educational Programs here at ELI, and I'm so excited to welcome you all to today's program. We have a fantastic lineup for you. As you all are very well aware, it was a busy year in environmental law with numerous important regulatory and legislative developments. Our speakers today will give us an overview of the key developments from the last year and what we can expect in the next. So a huge thank you to them for undertaking this massive task. I also want to thank all of you for tuning in to our first program of the year. We have a great year of events ahead and we can't wait to share them all with you. Now, following their opening presentations today, our speakers will have a roundtable discussion and we'll also be taking some audience questions later in the program. So you can submit these at any time. You don't have to wait to submit them. Just use Zoom's Q&A function. It will be right at the bottom of your screen next to the chat button. Our moderator and our speakers will be able to see those. So again, you can submit those at any time. You can also use the chat for any observations and comments, but we'll be pulling discussion questions directly from this Q&A box. Now, today's webinar will be recorded and posted on our event webpage for ELI members to view later. So if you're an ELI member and you can't stay for the whole webinar, the recording will be available usually within a few business days. You can find that recording and more information on becoming a member at eli.org. Now, before we get started, I want to introduce our wonderful moderator, Sean Riley. Sean has been a reporter at E&E News since 2014, and he currently covers Clean Air Act policy. Topics on his beat include EPA's reviews of national ambient air quality standards for particulate matter and other pollutants, good neighbor litigation, a variety of air toxics regulations, and the Regional Haze Program. Prior to joining E&E, which is now part of Politico, Riley reported for the Federal Times and earlier served as Washington correspondent for the Mobile, Alabama Press Register. Sean, a huge thank you for moderating today's discussion, and I'll turn it over to you.
Delighted to be here, Sarah, and happy Tuesday, everyone, and welcome to what will no doubt be an engrossing and enlightening discussion. Hard as it is to believe, it's been almost exactly 3 years since the Biden administration took office and immediately began executing a reversal in numerous areas of the policies undertaken under former President Trump. As we move on from 2023, 2024 is looming as a pivotal year in terms of agency rulemaking, Supreme Court action, and an unpredictable Congress, all playing out in the shadow of the November presidential and congressional elections. Here to help us make sense of it all are three outstanding panelists with a wide array of expertise. Ava Uzad is the executive director of Avaz LLC, an environmental and animal law policy and advocacy firm based in the Kansas City metro area. Ava comes from an 8-year tenure at the U.S. EPA, where she most recently served as the PFAS managing attorney in the Federal Facilities Enforcement Office. At EPA, Ava worked across nearly all major federal environmental statutes to ensure federal agencies' responsible environmental stewardship and compliance with environmental laws. She also oversaw the ever-evolving universe of PFAS legislation, regulation, litigation, policy, and science, and their impact on federal agencies' management of PFAS products and waste. In addition to her extensive PFAS portfolio, Ava also served as Safe Drinking Water Act and Imminent Substantial Endangerment Authority expert for the Federal Facilities Enforcement Office and led staff on matters such as the Freedom of Information Act and environmental justice initiatives. Prior to EPA, her experience spans state government, the nonprofit sector, and the private sector with positions at the Kansas Department of Health and Environment, the Conservation Law Foundation, and Shook, Hardy, and Bacon LLP. She has published work on criminal procedure, international environmental justice, and climate justice. Next is Liz Malone, the head of environmental practice group at Skadden Arps. There, she helps clients navigate complicated and stringent environmental laws and regulations, advising on environmental risks, liabilities, and mitigation strategies. in corporate transactions, ESG initiatives and requirements, issues related to complex cleanup efforts, and litigation in state and federal courts and administrative proceedings. Then we have Alexandra Adams, who leads the Natural Resource Defense Council's Government Affairs team, including its federal and regional governmental affairs work. She works to develop proactive strategies to secure environmental protections while addressing legislative threats. Adams previously served as Senior Director of NRDC's Federal Affairs Program and Legislative Director of NRDC's Nature Program, working to secure historic climate legislation and coordinating NRDC's strategy for preventing legislative threats to lands, water, ocean, and wildlife. She also led NRDC's offshore oil and gas development work and served as the Ocean Division Senior Advocate in Washington, D.C. Prior to that, she held positions at national and regional conservation organizations, focusing on climate change adaptation, endangered species, and water resources. She graduated from the University of Florida and received a master's degree in environmental studies at Brown University. She is based in Washington, D.C. And with that, let's get started. Ava?
Thank you, Sean. Hi, everyone. As Sean mentioned, I am Ava Azad with Avaaz, and I will be kicking us off with talking about some major PFAS updates, as well as updates under the Clean Water Act, including Waters of the United States definition updates from the past year, and then looking ahead at 2024. I will let you know, just a couple of months ago, I was giving some PFAS presentations to some colleagues with everything you need to know about PFAS, and that took me over 4 or 5 hours. So I'm going to do my best to condense everything important on PFAS and Clean Water Act from 2023 into 10 minutes. So bear with me. Okay, next slide, please. Okay, I broke down the PFAS updates from 2023 by statute. I thought that was an easy way to kind of conceptualize them. I will mention that the updates that I'm going to go through are not exhaustive of every update upon PFAS from 2023. There are very many. For example, I don't get into all the toxicity value updates and a lot of the scientific updates, research and development updates, including some other regulatory updates and ones that I didn't quite capture here due to time. But I tried to pull what I thought was the most important for us to keep in mind in looking back at this last year. So starting with, going statute by statute, starting with the Toxic Substances Control Act, this is where we saw the most number of updates regarding PFAS over the last year. All of these updates, there were several proposed rules, there were several rules that were finalized, and all of these relate to when entities, primarily manufacturers and those that process PFAS, have to report to the agency on the PFAS that they either produce or import or use. And then also there are some updates about how the agency is going to review new uses of PFAS and new PFAS chemicals that would be entering into commerce. So just to hit on a few of these, in January of 2023, EPA put out a proposed significant new use rule for preventing certain PFAS that have been considered inactive from entering into commerce without a full review. And inactive is defined as PFAS that have not been manufactured, imported, or processed since June 21st, specifically of 2006. So that's the category. That's the 329 is fall into that category, and will now need to get a full review under this proposed rule, which actually went final this month. So that's an update that I have later, but reveal that rule did go final. So now these PFAS will be looked at going forward. In May, there was another proposed rule proposing a couple of updates to TSCA, including a review of PFAS. Sorry, I'm trying to remember. There were so many under TSCA. I had to kind of categorize them this way. Now I'm trying to refresh on what this one was. It basically says that having to come to EPA to get a review for a new use or use of a new PFAS compound or significant new use before a manufacturer or processor can use such start to produce or manufacture and put into commerce such PFAS compounds. And something that's related to this is a June 23 framework the EPA put out on how it's going to review these compounds when they're brought to the agency for manufacturing process. Also, it removed the proposed rules from May 2023 also proposed to remove an exemption that allowed certain new PFAS to undergo a shorter review process than would otherwise occur under TSCA. And then a couple of rules that were finalized in both of which in October, but these are separate rules, was one was requiring manufacturers and importers containing any PFAS containing articles since 2011 to report that information of that manufacturer and import to the EPA. And in October, also the agency developed a rule getting rid of another exemption that allowed entities that would have otherwise had to report certain PFAS to EPA that didn't have to because of a de minimis exemption that existed before. This final rule in October got rid of that de minimis exemption. So now any and every use of PFAS that qualify under TRI and are listed under TRI, regardless of the size or quantity of the PFAS, will have to be reported to the agency. And finally, under TSCA, I wanted to mention a PFAS testing strategy that comes up under EPA's authority under Section 4 of TSCA and allows the agency to require manufacturers and importers of certain compounds and chemicals to provide to the agency information that they have on those compounds or chemicals, or in some case, if they don't have data that would allow the agency to assess use of those chemicals, those manufacturers actually have to produce that data for the agency. And EPA has issued now 3 test orders under this testing strategy, 2 of which came out in 2023 in January and August. Those are issued to kind of the usual suspects of 3M, DuPont, Chemours, some of the major PFAS manufacturers. Okay, so those are some of the hits under TSCA. We can go to the next slide, please. Checking in on my time. I'm already going over. I'll try to speed it up a little. Then we had a significant update under the Clean Water Act from January as EPA released Effluent Guidelines Program Plan 15. Significantly, that included a plan to study discharges from several PFAS into POTWs, and it also proposed a rulemaking to address PFAS in leachate from landfills. So looking ahead, we'll want to keep an eye on as that planned rule develops. Under the Clean Air Act in July, the agency proposed doing data collection from facilities that emit PFAS into the air under the air emissions reporting rule. I think air is where we've seen, relative to a lot of the other major statutes, some of the lesser activity for PFAS. So it's nice to see this moving forward. There was a significant amount of money given by the agency under the bipartisan infrastructure law to address PFAS. There are 2 categories of funding that the agency got through bill and is passing on. It's the state revolving fund for emerging contaminants, which includes PFAS. And I think there's a major focus on PFAS, even though that's not the only category of emerging contaminants, but it's certainly a focus and a lot of where this money is going. And also a separate fund for small and disadvantaged communities to address emerging contaminants. There's a grant program there. So the agency in 2023 already distributed $1 billion under the state revolving fund and $2 billion under the smaller disadvantaged communities emerging contaminants program. Next slide, please. Okay, I saved some of the typically juiciest PFAS updates for last, ones that a lot of people are keeping their eyes on. One are, what is the Safe Drinking Water Act? You know, we're all looking at the drinking water standards that have been proposed and are waiting for the final rule to come out on that. The proposal came out in March of 2023 that proposed setting maximum contaminant levels for 6 PFAS in drinking water. There were 2 PFAS proposed for setting MCLs, PFOA, PFOS, and then a mixture of 4 others, where there was a precedential way of proposing to look at, you know, set MCLs is to look at a combination of multiple PFAS and consider them in the context of a hazard index, which is used in other programs in the agency, but this was for the first time the agency is doing this under the Safe Drinking Water Act. And so that proposed rule is slated to come out, I think, anytime early this year. So we're definitely keeping an eye on that. Also very significant under the Drinking Water Act, the Unregulated Contaminant Monitoring Rule 5, so the fifth iteration of the UCMR is out and includes collecting data on 29 PFAS. And the agency has started to, is receiving that data and is starting to post it now quarterly. So in 2023, in August and November, EPA posted the first and second quarters of results that have been received from the sampling there. So that's going to really show the extent of contamination for these 29 PFAS. Certain other PFAS have already been sampled in other earlier iterations of the UCMR. And now we're going to continue to collect more and more data and know just the prevalence of PFAS in water. And then under CERCLA, a significant action that was taken in 2023 is the advance notice of proposed rulemaking, seeking public input and data to inform decision-making on future regulations for CERCLA. So here, EPA asked the public to provide any data it has and information that the agency can use in considering which PFAS to, for example, potentially designate as hazardous substances under CERCLA going forward. And of course, there's already a rulemaking out that was proposed and is in the process of being finalized to designate PFOA and PFAS as CERCLA hazardous substances. But this rule would, considers that the agency would in the future add, designate additional PFAS either individually or as a class, also as hazardous substances in addition to PFOA and PFAS. I'll just quickly mention a rescission of a 2019 groundwater guidance here that was significant, but essentially the implication of that is reverting back to the regular process under CERCLA and RCRA for cleanup and identifying the levels at which certain PFAS will be addressed, and that is following regular risk assessment and then site-specific considerations. Next slide, please. A couple of cross-cutting PFAS updates from 2023 that were significant. In August, the Office of Enforcement and Compliance Assurance announced its priorities for the next round of national enforcement and compliance initiatives, so running from fiscal year 24 to 27. And for the first time ever, there was a national enforcement and compliance initiative announced for PFAS, which, as is the nature of PFAS, it was cross-media, cross-cutting across multiple programs in the enforcement office, but it emphasizes the enforcement office's focus on PFAS and the actions it's going to take to ensure that those who have been the cause of PFAS contamination are held accountable for that contamination. And then I also wanted to flag for everyone the PFAS analytic tools from EPA that were publicly released in January of 2023. They were subsequently updated. They will continue to get updated as more and more data comes out. For example, UCMR PFAS data that's included in the tools. This is a really good resource that's open to the public for anyone who wants to go and pull up a map. It has multiple data layers showing different information about potential sources of PFAS, actual data collected for PFAS, for example, under UCMR. Next slide, please. Okay, this I mentioned that one of the rules that I mentioned under TSCA was finalized this year in 2020, January 11th. That was the significant new use rule to prevent certain inactive PFAS from re-entering commerce. There were also certain PFAS added to toxics release inventory chemical list, meaning that those now have to be reported to the agency as well. So those are fresh updates from this month. Next slide, please. Some forecasting, looking to the future for PFAS. I won't run through everything here, just given time, please feel free to ask any questions. We can get into this more during the Q&A. But I think what everyone's going to be keeping an eye on here is the final MCL rulemaking under the Safe Drinking Water Act that's anticipated early this year. And under CERCLA, the final rulemaking for designating PFOA and PFAS as CERCLA hazardous substances. And there are also a couple of rules under the Resource Conservation and Recovery Act, RCRA, that I haven't yet mentioned, but there will be updates coming up on that too, with a couple of proposed rules that EPA has announced. Next slide, please. I'll move on to, I have more PFAS cross-cutting updates or a forecast, keeping an eye on the, there's some information that's going to be coming out with PFOA and PFAS and biosolids, a risk assessment for that, really being released for public comment in 2024. So something to keep an eye on there and consider for public comment. Keeping an eye on the National Enforcement and Compliance initiatives and enforcement that the agency takes under that initiative going forward as it ramps up. There is a PFAS destruction and disposal guidance that was to be released. It was slated for December of 2023, so it should be coming out, anytime now. It's an update to a 2020 PFAS destruction and disposal guidance that the agency issued as a requirement under that it was required to do by law. Okay, let's move on to Clean Water Act, and I will try to run through this very quick. Key highlights: in January, EPA issued a rule that revised the definition of waters of the United States for purposes of the Clean Water Act. Subsequent to that, in May, the Supreme Court came out with the Sackett decision, adopting essentially the Scalia plurality opinion about what the definition of wetlands should be under the Clean Water Act. And that was in conflict somewhat with what EPA had done in January and the definition that it had put out for the waters of the United States. So subsequently in September, the agency, EPA and Army, because EPA and Army Corps both implement the Clean Water Act, they together issued an amendment to the January rule to account for the Sackett decision. So there is an updated definition now of waters of the United States. The key thing to recognize here is that, and when considering an adjacent wetland and whether it falls under the jurisdiction of the Clean Water Act, you have to look at the continuous surface connection with a water of the United States rather than the previous significant nexus test that was used. Next slide, please. And there is some litigation occurring by several states and certain parties challenging the January 2023 WOTUS rule. So in those states, the EPA has been enjoined from implementing that rule at this time. So those are highlighted here. I pulled this map on from EPA's website, so you can look it up if you'd like to see which states are currently, in which states EPA and Army Corps are currently implementing the 2023 updated WOTUS rules, and in which ones, the 27, when there's litigation, they are applying the pre-2015 WOTUS rules in the meantime. Next slide, please. My last topic, Maui and Clean Water Act updates. The Maui decision was a Supreme Court decision from April of 2020 that held that if a pollutant is being put into groundwater that is the functional equivalent of a direct discharge from a point source into navigable waters, then that discharge needs to have a NPDES permit, essentially. Just because you are discharging a pollutant into groundwater and not directly into a surface water does not mean that you get to evade the Clean Water Act and the need to get a NPDES permit. So in November of this year, the EPA published guidance in how it may consider applying the Maui decision. That they put that out for public comment. The public comment period closed last month. So that's something else to keep an eye on going forward, is what the public comments were on this guidance the EPA published on how to apply the Maui decision, and then how EPA finalizes its guidance and then implements that decision. And what's key here is the Supreme Court's 7 factors that they listed for consideration in determining when a discharge from to groundwater is functionally equivalent to a direct discharge into a navigable water. I will cut it off there. I'm sorry that I went over. We can skip these last couple of slides. There's my contact. Happy to follow up, and I will pass it on to the next speaker. Thank you.
Well, thanks so much, Alva, for covering such an astonishing amount of material in a very short period of time. A couple references there to Supreme Court decisions. I hope here to help us navigate what might be coming up on the legal front is Liz.
Yes. Hi, thank you very much. I was going to talk a little bit about the regulatory action and court cases to watch in the upcoming year and kind of how they relate to issues that we saw in 2023 and how we expect to see those play out. So we can go to the next slide. All right, the major regulatory action that I'll be watching, the less of them, but EPA is expected to release its final rule establishing greenhouse gas emission standards for power plants. This rule was first proposed in May 2023. In November 2023, EPA sent out a request for supplemental comments that seemed to be driven by a lot of the comments they had already received and was focusing on issues like grid reliability and feasibility. The proposed rule reduces CO2 emissions from existing coal plants and new and existing gas plants. You'll notice that I did not say anything about new coal plants. The rule does not address those because EPA basically said no one's building new coal plants anymore. So the new source performance standards that are in place would apply. The compliance options depend on the type of plant you have, the date that you may be retiring if it's a coal plant, and the size of your plant. But basically the compliance options focus on carbon capture and storage, low greenhouse gas hydrogen co-firing, and natural gas co-firing. EPA is expected, or I should say maybe I think they're hoping to issue the rule in spring of 2024. That may be a little ambitious. We'll see. I wouldn't be surprised to see that slip till the summer. And then when we get the final rule, it will inevitably be challenged. The potential issues that I expect to be raised in court challenges are whether carbon capture and low greenhouse gas hydrogen co-firing have been adequately demonstrated. The Clean Air Act says EPA has to apply the best system of emissions reduction that has been adequately demonstrated. And I think there are open questions, we'll say, on whether those two technologies have been adequately demonstrated. I also expect you'll see people raising the major question doctrine that we saw kind of develop out of the West Virginia versus EPA case in 2021, when EPA struck down the Obama administration's Clean Power Rule. I don't think the major questions doctrine is as strong of an argument in this new rule because the rule is more closely tied to EPA's traditional kind of mechanisms for reducing air emissions. But I do expect that opponents of the rule will say that the rule is going to force a shift away from coal. And that is really a major question that Congress should decide. The rule also allows states to implement a cap and trade program for greenhouse gas emissions. But the Supreme Court in West Virginia suggested that EPA cannot do that directly under Section 111 of the Clean Air Act. So it remains to be seen if they can allow states to do that. So that's kind of a very high level overview of the greenhouse gas rule. Next slide. All right, methane emissions. So we'll have a lot of activity on methane in 2024. In December of 2023, EPA finalized a sweeping regulation that establishes standards for oil and gas infrastructure. State plans are due in 24 months to cover existing plants or existing sources. I think litigation will soon be filed over this issue. Among other issues that I expect to be challenged will be the so-called super emitter program, which is a program that allows third parties to use advanced technologies such as drones and overhead technology to detect major emissions of methane, and they call those so-called super emitters. If a third party finds such a super emitter, it can report that to EPA. EPA has to consider the data and then notify the source. And if the source is in fact, emitting these emissions, then it will have to take steps to reduce them. In addition, this year, we've already seen a new rule out of EPA, which establishes a methane fee under the Inflation Reduction Act. It basically imposes a fee on companies that exceed methane emission standards. The fee starts at 900. Sorry, my screen is cut off. 900 fees, and it will increase to 150 per ton in 2026. EPA kind of says that this fee is supposed to be a bridge to get us a reduction in emissions before the December 2023 rule really kicks in and addresses it. So EPA kind of views the fee as almost a temporary bridge to get us to the standards, but we'll see how that plays out in the courts as well. We can go to the next slide. All right. Key court cases in 2024, there are a lot of them. I've tried to just hit some of the major ones. There are, at the Supreme Court level, there are two cases you've probably heard talked about that are potentially challenging the Chevron doctrine. The Chevron doctrine was announced in 1984 in a case called Chevron v. Natural Resources Defense Council. And the Chevron doctrine basically says the judges should defer to an agency's reasonable legal interpretations in its rulemakings. Now, tomorrow, the court will hear arguments in Loper-Bright versus Raimondo and Relentless versus U.S. Department of Commerce. I like that case name for this issue, Relentless. But if the Supreme Court does decide to revisit Chevron and say that the courts don't owe agencies a deference, that could impact future EPA rulemakings. I know a lot of commentators have written about this and expressed concern about it. But I would kind of taper, any expectations about the sweeping effect that might happen by saying I think we'll still see deference to agencies on technical and scientific matters. And also, I'd note that the effect could work both ways, both when EPA tries to expand its authority, the loss of the Chevron doctrine could call that under scrutiny, but also there are times when the EPA says we don't have the authority to do this. It tries to contract its authority, and the loss of Chevron could play into account in those situations too. So certainly a case to watch. We'll see what the Supreme Court says about Chevron and how far it's willing to go in overturning that. Next slide. All right, so then there are 4 cases before the Supreme Court this term. Arguments are scheduled for February. These cases are challenging EPA's Good Neighbor Plan, which targets emissions from a number of upwind states. The arguments focus on whether the plan usurps states' authority to develop their own plans for controlling emissions, the vagueness of the standards, and the impossibility of complying. Again, I think the Supreme Court will be skeptical of the Good Neighbor Plan, but we'll have to see how that plans out. Next slide. And there are that should be vehicle emission cases before the District Court of DC. There are 2 cases that the courts already heard arguments on. They're challenging EPA emission standards and fuel economy standards for cars and light trucks. The major questions doctrine argument is here at play. Basically, the opponents of the rules have argued that the rule essentially mandates a switch to electric vehicles, which is a major question that the Congress has to decide. And then there is also Ohio versus EPA, which is a challenge to EPA's reinstatement of its waiver of California's waiver under the Clean Air Act that allows California to set its own greenhouse gas emissions for vehicles and to require certain percentages of vehicles sold to be electric. You may recall that under the this is a waiver that's been in effect for many years. The Trump administration rescinded it, and then the Biden administration reinstated it. And now the court is deciding it. So again, that will depend on both what the court rules and then what the election holds. We can go to the next slide. This is another Supreme Court case, Corner Post versus Board of Governors of the Federal Reserve System. I think this is a pretty interesting case. It's a challenge to a 2011 Federal Reserve rule on debit card swipes. And the issue is whether the 6-year statute of limitation in the Administrative Procedure Act begins to run when the rule is issued or when a regulated entity is injured by it. If the statute of limitations doesn't start to run when the rule is issued, then you could really open the door to a lot of rules being challenged that we thought were already settled. So it will be interesting to see how that plays out. We can go on. And then the last thing is just there are a lot of climate change cases involving constitutional rights and alleged trespass. As you may know, many of these have been brought by young people, children. The Montana Supreme Court is scheduled to hear an appeal of the lower court finding in that case, where the lower court found that young people's rights had been violated when state lawmakers prohibited agencies from considering climate change in permitting decisions. Also, we have a trial scheduled for June of 2024 in a climate change case against the state of Hawaii after the judge denied attempts to dismiss the case. There are also climate change cases in Utah and Virginia that were dismissed, and those are being appealed. And then there are also cases in Oregon and California in federal court that are moving forward. So will it be interesting to see how those play out? So far, the Supreme Court has not wanted to weigh in, but they may get involved depending on how things proceed. So next slide. Yeah. All right. Well, I will turn it over to the next speaker then. Thank you very much.
Liz, thank you so much. That was a fascinating overview. I was not even aware of the Corner Post case, but I'll certainly be looking forward to seeing how that wraps up or turns out. And so, Alex?
Yes, all set. Thank you so much. So you can go ahead and go to the next slide. And I appreciate everyone taking a little detour with me to talk about Congress and its impact on climate and the environment. I'm going to do just sort of a short look back and then an assessment of where we currently are. So really briefly, in 2022, we had a very heavy focus on moving forward legislation that would have a meaningful impact on reducing CO2 emissions. That was ultimately successful, and I'll talk about that success in a minute. But as you've all seen in the last year, Congress has been really stuck in gridlock, making it nearly impossible to pass proactive environment or climate legislation. And this has meant that the primary focus has been on the appropriations process, just given that it's one of Congress's primary jobs in keeping the government running. And because of that, we're seeing most environmental impacts play out in that process through either policy amendments that we call riders, potentially starvation levels for agencies like EPA, DOI, and amendments to reverse the climate gains that we made in 2022. We can move to the next slide. So, here are the climate wins that I'm referring to. The Inflation Reduction Act that was signed by President Biden in August of 2022. To pass this legislation, Congress used a tool called reconciliation that can be implemented to move forward high priority fiscal legislation. As many of you know, it was created by the Congressional Budget Act of 1974, and reconciliation really allows for expedited consideration of some of the tax, spending, and debt limit bills. So in the Senate, what's really key here is that reconciliation bills are not subject to the filibuster. So instead of needing 60 votes, a reconciliation bill only needs a simple majority in the Senate to pass, and that's how this bill was passed. Next slide, please. So a little bit about this legislation and why it's relevant now. Because it was a funding bill passed through reconciliation, the legislation was built around investments in clean energy to help us reach our greenhouse gas emissions reductions goals. The bill ultimately provided $369 billion in strategic investments over the next 10 years, starting from the implementation of the law. And that was designed to drive the growth of clean energy and reduce the nation's carbon footprint. Another key goal that was really important to those of us working on the bill was to create good paying jobs and support local communities. And based on NRDC's analysis, we believe that the IRA will position the US to cut greenhouse gas pollution by about 40 to 41% below 2005 levels by 2030. Next slide, please. Okay, so I want to talk about the IRA as it's sort of defending historic climate gains in the situation we are now. To see these emissions reductions realized, we need to work to ensure that the climate gains aren't rolled back in this current congressional process we're currently seeing. And there are three areas where rollbacks to these provisions could occur that puts that climate progress in jeopardy. And I'm going to share a bit about where we are in the appropriations process, and then a bit about climate and the Farm Bill as it relates to these processes and the Inflation Reduction Act. Next slide. So as you've seen, the House and the Senate have not been able to agree on appropriation bills to date, and the House majority has had shifts in leadership that have been sort of connected to this process. With Speaker Johnson taking the speaker role, he proposed a quote laddered continuing resolution following the first one that the previous Speaker McCarthy agreed to. I'll just note that this is not typical. You can see on this slide that government funding is now tied to two deadlines for differing agencies. The first part of that laddered CR expires on January 19th, right around the corner. And that part of the CR covers the Department of Agriculture, the VA, Department of Transportation, Department of Housing, and others. And the second one expires on February 2nd. And the funding in that part of the continuing resolution funds the Department of Commerce, Justice, DOI, Labor, Health, Human Services, State, etc. Next slide, please. And so continuing our current status, Leader Schumer and Speaker Johnson reached a top line funding deal, and that included $772.7 billion in non-defense discretionary spending. And that was roughly even with fiscal year 2023 levels. So now that that has occurred, Senator Murray and Representative Granger, who chair their respective appropriations committees, will work on top line budgets for the 12 individual bills that follow. Once they reach a deal on allocations, then subcommittee chairs can work out the details of each bill. And you can probably tell as I'm describing this process takes a long time, much longer than we currently have before the government runs out of funding. I'll also note that some of the bills we've seen previously proposed in the House have been what I would characterize as fairly damaging for issues that we care about. For example, the House majority's agricultural appropriations bill cut overall funding for the agency to the lowest levels we've seen in about 20 years. That was more than $10 billion below FY 2023. It also rescinded $5.7 billion from Inflation Reduction Act programs that address climate, benefit rural communities, farmers and ranchers, small businesses, etc. So the only upshot here is that bills like that have not been able to gain bipartisan or bicameral support to date. And so it appears now that in order to make these deadlines that we're looking at, we'll need yet another continuing resolution in order to do that. Speaker Johnson and Leader Schumer have just offered a clean continuing resolution. When we refer to clean CRs, it means that there's not riders on it that try to implement too much policymaking, that it's really just about keeping the government open. This new proposed continuing resolution will expire March 1st and March 8th, continuing that quote laddered approach that we're seeing. And the Senate's going to likely vote on this today. I haven't looked at current status of what's happening, but I certainly will and will keep you posted. And the House later this week. If these do pass, Congress still has a lot of work to do to complete this process. So we're really going to be looking at what do these final bills look like? Are Inflation Act reduction programs protected? And are we allowed to sort of see that play out in the climate reductions that we've planned for? Next slide, please. And then the other thing happening on the Hill that relates to must-pass legislation that this Congress will necessarily have to address is the Farm Bill. And the Inflation Reduction Act is implemented through the Farm Bill as well, in so much as that included funds to boost climate smart conservation practices, expand rural clean energy development, promote agroforestry, and bolster resources for underserved and at-risk farmers. And so these historic investments will help protect the livelihoods of farmers and other producers, but it will also secure a safe, reliable food supply as we look towards a changing climate, and in addition, reduce climate emissions from the agricultural sector. And that sector accounts for about 11% of the total US climate emissions, so it's significant. And I would just say the Farm Bill's reauthorized every 5 years, and this one was just extended in the last year through September. So negotiations on the bill are happening now, and protecting these critical investments is going to be really key to making sure that we have positive environmental outcomes in a Congress that's as deadlocked as this one is. And so, you know, I'll keep this short, but as you can see, those of us who are working in Congress to advance community, climate, and environmental protections are all focused on defending them in these processes that must play out. They're the must-pass bills that will get through and even heavily gridlock Congress. And I know there's going to be a discussion, so I'll pause it there, and I'll be happy to answer questions with the rest of the panelists.
Thank you so much, Alex. A lot of moving pieces here, and I think it's going to be a very, very busy week on Capitol Hill.
It will.
To move on to the next phase of our discussion, I'll be pitching a few questions to our panelists. The first couple will be open for anybody, and then we'll have a few specific ones. The first, and again, this is for all three of our panelists. In your view, what will be the most important regulation to be finalized in 2024?
Well, I can start. I'm certainly keeping an eye on EPA's power plant rule. If I had confidence that it wasn't going to be immediately stayed by the Supreme Court, I would say that's definitely the most important rule, because it could really have wide impacts on energy, the economy, and climate change. But I am skeptical that it will be enacted. I think the Supreme Court will continue to restrain EPA's action in this area, and will await further congressional rules. So that's my thinking.
Okay. Alex, Ava?
Sure. As I was thinking of the answer to this question for PFAS, I think that the answer is it varies depending on who you are as far as what's the most impactful, what's the most important. I think for the average American, the drinking water standards for PFAS are hugely important, long awaited. And I think everyone who drinks water is interested in that. So I think that just, it's very far reaching. As far as impact on actions required as a result of the rule, of course, you could see that the list of the updates under TSCA and a lot of the proposed rules that might be going final that will impact manufacturers. But if you're a PFAS manufacturer, you're kind of hit across the board. You're going to have to, there are eyes on you across the board under multiple statutes. But I think as far as having to being a regulated entity, that kind of changes what the most important thing is to keep an eye on. But I think for the average person, probably the drinking water rule is most hard hitting.
Indeed. Alex, I know this is a little bit off the government affairs beat, but anything you would add?
I would just say that I think both Liz and Ava really talked about the things that were important to those of us who are working across the board on climate, water, health. I think PFAS is really fascinating. It was very interesting listening to this presentation for me, something that really affects everybody's health, and the climate regs, a number of them. So we're keeping an eye on all the ones coming. It's going to be a very important year.
Thanks. And a quick reminder to follow up on Sarah's note in the chat, we will be taking audience questions a little later on. So if you've got any, please submit it through the Q&A tab at the bottom of the screen. Next question, and Liz has already discussed this in depth, but I'll certainly be interested in any further thoughts. What will the Supreme Court do in 2024 to affect energy and environmental policy?
Yeah, so I think, just to talk about the power plant rule a little bit more, I think one thing to watch is there's been some discussion in the last few weeks that EPA may be reconsidering including low greenhouse gas hydrogen co-firing as a compliance option. My understanding is they may be reevaluating that on the grounds that it's not adequately demonstrated. And the issue with that is that, under the rule, you can't use hydrogen that uses, fossil fuel energy to generate the hydrogen, because then you're not really making any impacts on reducing emissions. So you have to use hydrogen that's produced in a way that is clean, has low greenhouse gas emissions in it, and that's just not readily available in the United States at this time. And with carbon capture, again, there's a debate on whether it's reasonably demonstrated. As of the summer of last year, I think there were 15 facilities in the US that had some form of carbon capture, but most of those plants are natural gas processing plants or plants that produce ethanol or ammonia for fertilizer. They're not traditional, power generating plants. I think there has been one coal plant in the United States that has had carbon capture installed. That was in Houston, and the project was mothballed in 2020 due to just collapsing prices, and the COVID pandemic, I think, also contributed to that. So, there are, on the other hand, lots of companies who are investing in this. I think there are 121 projects as of last summer in development. So I guess, I would say, the Supreme Court's going to have to say, if you have a technology that, we know works, but hasn't been largely deployed, but maybe largely deployed in the coming years when the deadlines kick in, is that adequately demonstrated? I mean, that's what the Supreme Court will have to wrestle with. And I suspect they're going to want to see something that has been rolled out, maybe not on a full commercial scale, but rolled out a little bit more than carbon capture has.
Thanks. Alex, any court cases, Supreme Court cases you're particularly keeping an eye on?
I wouldn't dream of answering that without my litigation team.
Well, how about we move on to another question more in your bailiwick? What will Congress, and I know you've already discussed this, but there's probably ample room for further discussion. What will Congress do in 2024 to affect energy and environmental policy?
It's so interesting. I really focused on must-pass legislation. I think that that's going to be the place where everything happens. Also, Congressional Review Act votes are going to be really important. I think that we're going to be looking at a lot of focus on trying to affect policy through funding legislation and through bills that just have to move through this Congress. I don't think we've seen so much shifts and gridlock as we have now. And it's going to be very interesting as we go up to a place where we have to keep the government running. And also, I think, in addition to keeping the government running, how we're funding these agencies has a huge impact on how they can really perform to protect health, environment, climate, and air quality, water quality. Some of these starvation levels for agencies really, I think, would be really problematic if they were allowed to move through. At this point, I'm feeling slightly hopeful.
Could you mention the Congressional Review Act? Could you talk a little bit more about that and how it could play out, particularly in regard to regulations finalized later in the year?
Sure. So, Congress has the ability to really, I guess I would just say, take a vote on rules and regulations that are implemented by agencies. And part of the Congressional Review Act, we call it sort of a really blunt tool, because once it's voted on one of those regulations, it then states that you can't reissue that regulation or something similar to it. So if there are any of these regulations that are issued and they fall within a time frame where Congress could take a vote using the CRA, it would mean that the risk of being able to create rules that protect human health are going to be at risk. And again, it's kind of a situation where we keep a close eye on what CRA votes are being considered, because you really want members of Congress to understand the gravity of that type of a vote and what it can mean for being able to protect the environment, protect human health, and have agencies do the jobs they're really being asked to do.
Thanks. Question specifically for Ava. Apart from what you've already discussed regarding PFAS, anything in particular you're watching for in 2024 related to PFAS regulation or policy?
I think in addition to it, to highlight that drinking water rule again, I think something that a lot of people might not consider that shows the impact of an MCL is that it wouldn't just be in the context of drinking water, but it could also extend to cleanups, for example, under CERCLA. Standards from other programs are pulled in as applicable or relevant and appropriate, and those standards have to be met when responsible parties are cleaning up at Superfund sites. So I think, again, the impact of that is significant once that MCL rulemaking goes final in the drinking water context, not just for drinking water, but also for other programs. Something that I always keep an eye on from year to year for major PFAS updates congressionally is the National Defense Authorization Act, which has been over the last several years how Congress has made past updates for PFAS under either impacting multiple environmental statutes, putting requirements on EPA or DOD or other federal agencies. I was surprised in the fiscal year 2024 National Defense Authorization Act to see relatively very little on PFAS. So we'll see how that happens going forward, and that might be because of all these actions that EPA is taking. EPA and a lot of other federal agencies are taking very proactively. So I think, those are some things that I did look at, and now considering looking forward is that drinking water rules is significant, and a lot of the, I think the hazardous substance designation as well. Under CERCLA, again, there's some overlap there.
Interesting to see how the Defense Department authorization becomes kind of a catch-all for regulations or policies that may not seem directly related to DOD or to defense. One final question for Liz, and we haven't really talked about this so far, but I think most people in our audience be familiar with ESG, an abbreviation for environmental, social, and business governance, as a way of evaluating companies' actions. What do you see coming up in that regard this year?
That's a great question. I think there's going to be a lot of activity, both pro ESG and anti ESG. There is a challenge currently pending to a Department of Labor rule that said that plan managers under ERISA can consider ESG factors when making investment decisions. That rule was challenged and upheld at the district court, but it is on appeal to the Fifth Circuit. So I expect a decision on that, which I'm sure the losing party will take up. There is a rule proposed in Missouri that requires investment advisors to attain a client's signature before they give advice that may have an ESG component to a financial question. We'll see if other states start to adopt that. We're certainly seeing some of the so-called red states adopting more and more anti-ESG legislation. There are also a couple cases pending where participants in 401k plans have sued their employers, saying basically you breached your fiduciary duty under ERISA or state laws by taking into account ESG factors instead of just looking at the financial performance of the funds. So there's one case against American Airlines, and I believe there's also a case that has been brought by against 3 pension funds in New York City challenging those. So those are kind of we'll see what happens on anti-ESG legislation in court cases. But I also, there is a SEC proposed rule on climate change disclosures that's been pending for at least a couple of years now. It's a very broad rule that would require companies to disclose their climate risks, as well as their Scope 1, Scope 2, and Scope 3 greenhouse gas emissions. I think the SEC is going to want to finalize that rule this year, and hopefully hopefully from their perspective, they will get it done before the Congressional Review Act period, kicks in for the new Congress. So that would be, 60 days before January 2025. We'll see what we'll do if they'll do that. I also wouldn't be surprised if the new rule is significantly different from the proposed one. They've had a lot of pushback on specifically disclosing scope 3 emissions and whether it's practical to ask companies to do that. Also on the verification issue, if there are just enough companies out there who can verify companies' emissions data. So we'll see what the SEC says on that. At the same time, California in October of 2023 passed 3 climate change disclosure laws that are very broad, and they apply to basically large companies doing business in California. So it will impact international companies, not just California entities. And those rules are very kind of similar to the proposed SEC rules. They require broad disclosures of climate risks and your emissions. Those disclosure rules kick in January 2026. There's also a California rule that relates to disclosures companies have to make if they're making green claims about their emissions. So if they say they are on a path to be net zero, or that they have reduced their greenhouse gas emissions by 50%, claims like that, you have to have on your website information substantiating those. So I expect to see a lot of companies ramping up to comply with those, and they could. The SEC may feel more comfortable issuing a broader rule now that these rules in California are in effect. So that will be interesting.
A lot to keep an eye on.
Yeah, absolutely.
Okay. Well, we're now going to move to audience questions. We have about a dozen or so in the chat. We're certainly going to try and get, or the Q&A, and we're certainly trying to get as many as we can. Please keep sending them in as we move forward. First question, I think, is for Ava. And it is, going back to your presentation, what are quote unquote inactive PFAS?
Yes, under TSCA, the statute requires EPA to compile and maintain an inventory of chemicals subject to TSCA. And in that TSCA inventory, EPA has to distinguish between active and inactive chemicals. Inactive chemicals are ones that have not been manufactured, processed, or imported into the US since, June, I have the date, 21st, 2006. So anything manufactured, imported, or processed before that, but not after, is considered inactive.
And to follow up on that, another PFAS-related question. Do you see the September 24 timeline as noted in the most recent unified agenda for finalizing the PFAS drinking water reg is reasonable and likely to be met?
I do. EPA is actually anticipated releasing the final rule in early 2024. And so I think a September 2024, worst case scenario situation is a reasonable timeline.
Okay. And one more. Has there been any chatter on the MQD? I'm sorry, I don't know what that is, as possible basis to challenge PFAS efforts?
MQD, I'm not familiar with that either. If you could let me know what that is.
If our questioner could provide a little clarification on what that stands for, we will come back to that question. Let's see, I think this one would be for Alex. Could the GOP Project 2025 plan be streamlined in this? I'm not sure in a similar way. If so, at what speed do you expect it could be implemented?
I'm actually going to defer on any electoral questions since I'm representing a C3. So anything that's not related to electoral issues, I'm happy to answer.
Sure, understood. And here's one, I believe, for Liz. Are any of the cases that you are seeing also listing the accounting firms in the lawsuits for not properly performing limited assurance of large corporate sustainability reports in conformance with the standards or formulas that they claim to report under their public-facing documents, i.e. GHG Protocol, SASB, PRI?
That's a great question. I I don't believe there have been any cases filed against the accounting firms. I do know that I think it was the Big Six, received a letter from a nonprofit last year that was basically saying, we don't think you're meeting your obligations when it comes to reviewing sustainability reports, and urging them to take a closer look. So I think that might be something that could come, but I think so far people are focused more on the companies themselves who are doing the reporting. But I don't think the accountants will be escape litigation altogether.
And here's one definitely for Alex. Going back to appropriations, what are things considered / feared most at risk in any budget deal that Biden and Schumer may be willing to trade to get a budget deal?
That's a great question. I don't have evidence of specific items that are, let's say, on the table. Groups like mine, we really try to do our due diligence and identify the things that are most impactful for reducing CO2 emissions and protecting communities, and making sure that the White House and members of Congress understand why we view those as being so important. So that was partially why I focused on the Inflation Reduction Act potential rollbacks in appropriations. That's something that we're going to continue to be very vocal about, just because it's so important. I will say that, we believe that, a government shutdown is terrible for everyone, and finding a deal is going to be really important. That said, it doesn't seem to me that there's anything very specific sort of hanging out there right now that people are worried about. It seems like negotiations are reasonable and measured, and we're going to keep our fingers crossed that they remain so. But you'll hear groups like mine talking about Inflation Reduction Act, talking about a potential, quote, poison pill policy riders, anything that, let's say, an amendment that's added that is very damaging to Endangered Species Act. Those types of things we're really going to be vigilant about.
You got another election related question, which I will pass on. Here's one I think for any of our panelists. With the current Supreme Court and the gridlock Congress, do you think we will see more cases from industry and business groups to roll back environmental protections this year?
Yeah, I mean, I think you will on new regulations. I think that's just kind of the path that we're on. But I think that I do want to say that I do think that there are a lot of companies who, when they see the proposed rules, they start planning to comply with it, and they want to do the right thing. I mean, I think most people have really gotten the message on the importance of ESG, the importance of climate change. So I think they are moving forward, and I don't think a lot of companies want to be seen as the one who is resisting those changes. To probably see more continued reliance on industry groups to kind of advocate for that. And you see a lot of companies saying, yes, we agree that we need to reduce methane emissions, but let's do it a little slower or a little more cost effectively. So I think you'll continue to see a dialogue, and new rules will be challenged. If the Republicans win the presidency, the new rules under Biden will be undone. And then you just keep, so a lot depends on the election too.
Right. And I'm sorry, go on.
I would add to that, I think for PFAS, I would expect most, if not all, the rules to some way be challenged, even if not formally, but a lot of them formally. I mean, I think we all anticipate that there are a lot of parties who are going to have a lot of significant concerns as these become final. I think a lot of the concern is for impacts that Liz mentioned this in a different context of concerns about sweeping impacts that I don't think will be the case. For example, about once a particular rulemaking goes final, that EPA is going to go out and pursue any and every possible party to the strongest, to the strongest extent to hold them accountable for every little bit of PFAS that gets out into the environment. And I think there's a lot of doomsday concerns around a lot of the PFAS regulations. And I think in part fueled by that, regardless of how accurate they might be. And then also for the entities that are going to be impacted, certainly like a lot of the manufacturers and people who are handling all of the PFAS, yes, I think there will be a lot of challenges as a lot of the PFAS rulemakings go final. And we saw with the January WOTUS rule that already has been challenged and is undergoing litigation. So there's a lot that's ongoing already.
Could you clarify what you meant by doomsday predictions, or if I understood you right?
I've noticed it a lot in the context of the Circle Hazardous Substance designation for designating PFOA and PFAS, two of the thousands of PFAS as hazardous substances under the Superfund cleanup law. There are a lot of concerns from many categories of entities about being held liable for having to clean up extensive amounts of PFAS contamination in the environment. For example, there's a lot of concern from farmers who have used biosolids that we now know are contaminated with PFAS, and now those are out into the environment. And airports that have used firefighting foam, firefighting departments that have used firefighting foam that has PFAS in it. Airports, for example, were required by federal law to use those that particular kind of firefighting foam that contained PFAS, and they're concerned now that the federal government is working towards regulations that are going to then allow the federal government to go after them for something that they were required to use by the federal government. So there's a lot of concern about the outcome. I think, as with everything, it's not like the day that a rule goes out, EPA is going to be going out and issuing orders, and there's an implementation period, including for the Safe Drinking Water Act, which I've mentioned a couple of times, of how significant that is, and we're all keeping an eye on it. Even once that rule goes final, there's an implementation period. So public water systems that are providing water to people are not going to be expected as of day one of that final rule to have no PFAS in their water. They have a period of at least 3 and up to 5 years to put in infrastructure, get necessary funding, update their infrastructure, put in treatment if they do have PFAS that they need to treat in their drinking water systems that is covered by this new rule. So that's what I meant by doomsdays. I think a lot of concern of a lot of enforcement action and being held to clean up a lot of PFAS from a lot of different parties, small and large. That just isn't how it comes out in practice.
And we got a response from our questioner about what MQD stands for. It is the Major Questions Doctrine, which I should have thought of. So the question, and I think this would be for you as well, Ava, is has there been any chatter on the Major Questions Doctrine as a possible basis to challenge PFAS efforts? And obviously, Liz, please feel free to jump in.
Trying to think of anything in the context that I have looked into. Nothing is jumping to mind. So Liz, if you have anything to add here, and I'll give it a little bit more thought.
Yeah, I haven't seen the Major Questions Doctrine discussed a lot in the context of PFAS. What I mostly see people focusing on is just the science behind the data of how harmful PFAS are. Also the scientific ability to detect it and clean it up at these low levels that we're seeing the standards set. I think that's kind of where the focus will be on, and certainly where they have been the challenges so far.
And this one is for anyone, I think. Could the speakers please weigh in on legislative or judicial changes impacting independent agencies in particular? And maybe get clarification on what independent agencies are, just for anyone not familiar with that term.
I assume they might be talking about like the Consumer Protection Agency. And that is outside of my expertise. I'm sorry, I can't be helpful.
Would the Securities and Exchange Commission fall in that category?
Oh, well, yeah, that's right. This question could also be talking about there's a case before the Supreme Court challenging agencies' ability to have kind of quasi judges, and that is being challenged at the SEC. I think that the Supreme, I think the Supreme Court will likely rein that in a bit. It can be a little disconcerting when you have someone from an agency make a decision that you don't agree with, and your only option is to appeal that to his boss. So, you know, I think that the Supreme Court might get involved a little bit there and weigh that in.
Anyone else have any thoughts on that? Here's an interesting one. Do any of you foresee any court cases and/or legislative changes to emergency response, disaster planning, and increased risk of climate disruption, natural disasters?
I will say that there are a number of members of Congress working on legislation as it relates to all of these issues, flooding, insurance, how we deal with it at the federal level, creating potentially special directives to agencies to handle this. And there's some really incredible ideas out there. What I will say is I don't see a lot of opportunities to get those passed in the next year. I think it's something we should all be focusing on. And, you know, my institution will continue to work with members of Congress who are interested in doing this, and look for opportunities to get that moving. But from the legislative perspective, there is focus on it. It's just a question of how do you get something like that passed in this type of a lot of friction in a Congress with very few spaces for votes to swing from one to the other. So yeah, unfortunately, it doesn't look great right now legislatively, but something that's super important. People are working on it.
Yeah. Liz, anything on the litigation or court front that would be worth noting here?
Yeah, I think you'll continue to see cases like whenever there's a major natural disaster, I think you will see litigants seek to recover damages from companies that are large greenhouse gas emitters if they think there was a hurricane that was kind of fueled by climate change. We've seen those in the past. I don't think that they've had great success in the courts thus far, but there are some still pending. And you know, I mean, some commentators kind of liken these kind of climate change tort cases, if you will, constitutional right cases, to the tobacco litigation that we saw years ago, which is just trying to get momentum. And then if you cross that barrier, you can see major liabilities. So I'm very interested to see how the courts are going to resolve that. And if they're going to say, look, this is a political question that courts are not equipped to decide, or if they're going to go like the Montana court and say, no, courts can weigh in on this. So that will be very interesting.
Yeah, it's a lot at stake. And while we're on the subject of climate, do any of you expect finalization of or litigation of, in parentheses, the federal acquisition rules, I think federal acquisition regulation, proposed rule regarding climate risk reporting / risk reduction plans?
I don't have much to say on that. I don't know if our other panelists are more familiar with that than I am.
I'm
I
afraid
can say
I'm
from
not.
my previous job that federal acquisition is a world unto its own. Moving over to WOTUS, have there been any updates yet about the definitions of, quote, relatively permanent and, quote, indistinguishable in reference to WOTUS?
You see, not those two in particular that that I have seen. I think, you know, the court, in trying to pull up the exact language, I had it noted down. The court in Sackett said essentially they use terminology like it would be difficult to determine where a water ends and a wetlands begins. If we're talking about the definition of indistinguishable there. But no, I haven't seen any particular definition of that.
To be coming, I'm sure. We'll see lots more on that.
And are any of you aware of any pending rulemaking related to or dealing with microplastics? Those were in the news last week, I think based on a National Academy study. Anything going on there that might be germane to that, to regulation of microplastics?
Yeah, lots of state action. Lots of state action. I'm not sure. I mean, if EPA has a kind of national plastics strategy that they are continuing to solicit comments on, but I don't know if there'll be any major rulemaking. EPA has issued an order to a manufacturer to stop them from using PFAS in their plastics. And the New York Attorney General actually recently filed a case against Pepsi, basically saying that Pepsi's single-use plastic products are littering New York and are polluting the waters, and basically that their use of the plastics, which other people are throwing away, constitutes a nuisance. So will be interesting to see how that case progresses.
What kind of state actions are being taken, apart from what you just alluded to?
Yeah, so I believe just they're banning microplastics in various uses. I know cosmetic uses are under scrutiny, and EPA has in the past taken regulatory actions on that. And states are just moving more and more to banning microplastics. And so I know if you I don't have a survey, but I think that, you know, if you California, Connecticut, Colorado, I believe all have rules on phasing out plastics.
And this was probably for Alex, but what is the 2024 date that final rules must be issued in order not, in capitals, to be subject to the Congressional Review Act?
I wish there was a hard date. It's actually not as easy to give a hard date as you would think, because it's based on legislative days in session. But I would say, to be safe, by end of April, probably.
Oh, that soon.
Yes.
All right.
And even then, when I say be safe, I mean, it's again, I think the misconception is that it's 100% easy to determine, and there's some variables that make it a little bit more fluid.
Mm-hmm. Okay. And let's see, got a few more here. Has there been litigation against state and local governments for not taking enough action to address climate change, such as to address increased frequency of flooding? And is that any more successful, generally speaking, than suing major greenhouse gas emitters?
So there are the case in Montana alleges that the state lawmakers violated children's constitutional rights by not allowing agencies to look at greenhouse gas emissions in permitting. And in that, you know, the lower court agreed with them. So I think that it has, you know, that's one example of it being more successful. I'm not sure if flooding has particularly been an issue. I know that in the past, the Army Corps of Engineers has been sued related to flooding in New Orleans, and there's been some success, some traction that those suits gained. So yeah, I think it'll just, you know, until there's a consensus among the courts that these types of cases should not proceed, I think they'll continue to come.
And something we haven't talked about is the National Environmental Policy Act, although members of Congress certainly talk about it a lot. Questioner asks, or says, there were significant changes to NEPA in 2023. The statute was amended, and we are awaiting the Phase 2 final rule. Would anyone like to comment on this?
I feel like NEPA gets reformed every there are efforts to reform NEPA, certainly every presidential administration. Sometimes it feels like every year. And I do a lot of renewable energy project developments where we go through NEPA, and I haven't seen improvement in the process. It's a valuable process. It relates in some really good changes to projects that are great, but it takes a lot of time. It's very expensive, and I am not I'm not optimistic that the final rule is going to achieve the objectives that it seems like everybody agrees on, which is we want a robust NEPA review process, but we also want to get these wind and solar projects going. So it's a really tough balancing act.
Alex, is that something you're following at all?
Yes, I will confess I'm not the point person, but I spend time looking at this a bit, and I would just say that based on sort of the closer look we've taken, it seems like NEPA is often blamed for delays that have more to do with not properly staffing agencies and providing enough funding to get these things done. And so there's a lot of ways to ensure that you have an important and proper NEPA process. As Liz talked about, it is really valuable. And I think it's scapegoated a lot when really it's not the NEPA process that's the problem. It's how we're ensuring that we have the resources to do it and to do it well. And so I think that brings us back to my central thesis that I keep forcing: the appropriations process and how we're funding our agencies to do the work that we expect of them. And yeah, that's probably my final word on NEPA for the day.
Okay.
Yeah, and I agree with you completely that it's really a staffing and a funding issue primarily. And I just wanted to say, with the methane rule that EPA passed in December 2023, you're going to have that issue at the state level too, because a lot of states have said we don't have the staff and we don't have the funds to implement the kind of methane rule that EPA is asking us to. So those are going to continue to be real challenges, because the federal government, state governments, local governments, everybody's under pressure to reduce costs, but they keep getting these new programs that need to be that require people and money to implement.
Execution is very important.
Yes.
And since you alluded to methane, I know you already talked about this, Liz, but I've got a question from someone asking about pending rulemaking in the oil and gas space. You alluded to some of this. Is there anything else you would add apart from what you said in your presentation?
Yeah, I've been focusing mostly on what's coming out of EPA, which is focusing on methane at oil and gas facilities. I know there is a lot of stuff going on at FERC as well, but that's less my space. So,
Anyone else want to touch on that subject?
No, but I do have something in response to the question about the relatively permanent standard.
Okay, go for it.
We don't have any more on the oil and gas. I did come across something, and I'm sorry I didn't have this handy earlier. EPA has done some analysis on how to determine when something is relatively permanent, specifically in the context of tributaries, and then that applies to other parts of other water entities that come in under WOTUS as well. So just hitting on some of the considerations there, they look to, in this case, they're talking about tributaries that are flowing or standing year round and continuously, not only at certain times of the year. They do not consider water entities that come into existence only as a result of direct precipitation, only at certain times of the year, in result only to precipitation. So they look at the duration of the flow, the timing of the flow. So there is some language from EPA on an analysis of the types of things they consider to make that determination.
Okay. We're almost to the end. Any final thoughts before we close it out? Nice. Let Sarah wrap up.
Just thank you so much for giving us the time to speak together. It's been so wonderful to hear these other perspectives. They're really valuable, and it's a pleasure.
Yes, agreed. Thank you all.
Great. Thank you. It's been a terrifically informative presentation. Sarah?
Hi, sorry everyone. Hello again. Thank you guys all so much. This was really an amazing way to kick off the new year. Thank you to Sean for jumping in and moderating, and to Ava, Elizabeth, Alexandra, all for such an engaging discussion. I know I learned a lot, and I'm sure everyone who's hanging out with us has as well. Was certainly no small feat to cover all of this ground in only 90 minutes, as Ava said in the beginning. So thank you all, and thank you to our wonderful audience for hanging in there with us. I'm sorry we didn't have time to get to everyone's questions there at the end. But we do have a lot of upcoming programming around a lot of the topics that we talked about today. So we have just later this month, we'll have programming around PFAS, the new methane rules, Loper Bright, Relentless, and so much more. So definitely check those out at eli.org. And if you joined late or couldn't stay for the whole presentation today, if you're a member, you'll be able to watch this. It'll be uploaded in the next few days on our website, again, eli.org. So thank you to everyone for joining us today. And until next time, I hope you have an amazing rest of your day. Bye, everybody.
Thank you.
Bye-bye.
Bye, thank you.
Thanks. Bye-bye.